feel free to get those ready for Niuscha and for Mariel. And without further ado, I hand it over to you, Mariel and Niuscha.
Good morning, good afternoon, everyone. I'm in Spain at the moment, so we're spanning quite a few time zones with everyone in Australia. Thank you for dialing in. As you all know, I am a card-carrying common lawyer most of the time, but did spend quite a bit of my time in Germany, where I also got to know Niuscha better. Niuscha has also done a lot of work in this area, including a keynote speech that she held in March this year at the Finland Arbitration Institute, if I'm not mistaken. So she's a true expert on this and gives a different perspective to what we're doing. So we'll dive straight into it. So Niuscha, what I'd like to first explore with you is what we're actually talking about here today. What is a facilitated settlement, and importantly, what is not?
Thank you very much, Mariel, and thank you very much, Emily and ICC Australia. Good morning, good afternoon, good evening. It's a pleasure to see you all here on screen. So what is it not? I can quickly say it in one word or in 2 words. In fact, 3. It is not mediation. So meaning that we are within and we stay within the arbitration sphere, will stay within the arbitration proceedings, and therefore we actually do not change any dispute resolution means. We stay within the arbitration proceedings, and while the arbitrator has the extra task, I purposefully do not say is putting on another head. No, it is an extra task to facilitate settlements. And the facilitation of settlements, that can be done by means of many different ways. There might be, of course, that much I admit, features of mediation as well in these facilitation of settlements. But one of the very, I would say, first and rudimentary ones would be already to even allow a settlement to be part of the proceedings. And for that to happen, the suggestion has been made by in-house counsel in particular as well, that, why don't we have difficulties going to management and to say we have to take the first step? So why can it not be somewhere in the rules or in the procedural rules or even institutional rules that there should be a so-called settlement window or settlement slot? And that's when it starts already at the beginning of the proceedings, where the tribunal would then not only, of course, remind the parties that they may also settle their dispute, but also that there would be a procedural step for that integrated in the procedural timetable by having the settlement window or settlement slot. We can discuss when that would be, when would be the best time for such a slot. In my experience, it must be at a time when there is already enough on the table in the record, exchange between the parties. The dynamics are completely different when you are actually in the proceedings. Prior to the proceedings commenced, the parties will have tried to amicably settle the dispute already, but the dynamics, as I said, are completely different once actually the request for arbitration is in, the answer is in, and also the statement of claim and statement of defense even. So that would be the first step already, to put in a settlement slot into the procedural timetable. Then in terms of the actual practicabilities, it can have an array of different elements included. And the very first one, and I'm sure a lot of you sitting as arbitrators are employing that already, is putting clarificatory questions to the parties. And clarificatory questions to the parties will have the effect of the parties and the council to maybe reassess their own cases as well, depending on how those questions are put. Of course, these questions that are put by the tribunal to the parties should not in any way prejudge or give even, you know, some kind of a hint of prejudgment of a certain issue. Again, we can dive into that a little bit more later on, but this is, I think, a very, very effective means for the parties to then see where their real weaknesses are if the tribunal actually is pushing and putting the finger even more on a gap in their argumentation. And then going then to another extreme from this year, so nothing is unusual so far, is to maybe even put preliminary views to the parties. Now, that is something that is, I think, the most critical one and the most criticized one as well when it comes to settlement facilitation, because this is where the tribunal might already step outside its management of the proceedings and have made its mind up. And we all know about confirmation bias, so we have to be very, very careful when we are stepping into that preliminary view sphere. Nothing is done without the parties' consent. It is clear that any step in this direction has to first be discussed with the parties whether they wish at all to receive preliminary views, and how these preliminary views are then going to be expressed. Is it going to be in writing? Is it going to be by means of a status meeting as a midstream conference? How is that going to happen? So, and what is going to be said? And one way that I have seen as well in practice is that the parties wanted to know what is the strength or the weakness of my argument, of my position. And it can be on one specific claim or head of claim, or several, or overall on the entirety of the party, each party's case. So again, care is to be taken, and this is, I think, something which is very Germanic to provide preliminary views as well. So I don't blame anyone who is not familiar with that or is raising eyebrows right now, but it, as I said, it is once it is done properly, it doesn't mean that the tribunal would be already tainted. I think the very extreme is to sit down with the parties and to have a settlement meeting. That is when then, which is also happening in German arbitrations sometimes, or other arbitrations I've seen in Europe as well, that is when indeed information is given to the arbitrator that the arbitrator may not anymore be able to get rid of. And so that is when you have then the problem of being, that your mind is, the hard disk is already then filled in with your views and also the parties, because they have then heard what the tribunal suggests as a good solution for a settlement, for example. So, and that's where I would take a step back if it fails and would recuse myself as an arbitrator, because I find it very, very difficult to then continue still as an arbitrator. So that was in a nutshell, basically, what it is and what it is not. Then, of course, the question is, as I said, it is Germanic, hinted as well, or at least civil law infused. Mariel, do you see that there is a shift in thinking in a common law lawyer's mind when it comes to facilitation of settlements? So has there been always this rift between civil law and common law lawyers? And if that's the case, then do we see maybe an amalgamation or a change in the common law lawyers' minds?
Thank you for the question, Niuscha. There's a lot to unpack there, including your very insightful comments into what the German system does. I have to say, expressing views on a case just as a principle fills me with dread, but I think anything short of that is somewhere, and I'm looking at the list of attendees in this call, so I feel incredibly underqualified to say this in isolation, but these are my personal views. I do think that the common law lawyers are warming up to the idea. I think what the idea is still requires definition, and that's to the first question. I mean, I've had cases where the parties have asked us to do a mediation, you know, the classic 2 weeks before the hearing where they're all panicking and worried about costs. And what we ended up doing largely as a product of Hong Kong law and what we could or could not do under the law as arbitrators being asked to sit as mediators was essentially in substance a facilitated settlement which failed, but they were calling it a mediation. So I think it's also about terminology, and part of, I think, warming up the common law world to what this is the terminology you use. I think in terms of where I am in Hong Kong, and this is, of course, very much a product of the one country, two systems system we have prevailing in Hong Kong with China. The Chinese love the idea of settlement. I've been in many events in Hong Kong where a Chinese lawyer has gotten up, and we've been talking about due process paranoia and all the usual procedural topics associated with arbitration. And someone has said something along the lines of, but why don't we just do it the way they do it in China, where the judge is allowed to facilitate and give views on the case? Now, again, not a Chinese lawyer, so I will keep my comments very superficial, but I do think the common law world is warming up. I do think acceptance, I think the principle is great. That's my personal view. I think it will avoid a lot of costs and time concerns, which everyone in the arbitration world is worried about, given where we are in the world right now. At least what I'm hearing in Hong Kong is that so many cases are settling before hearing, which is not good for the barristers and the arbitrators, or the law firms for that matter, but it's also a product of the extreme financial pressure that everyone's under. Whether or not that's with the arbitrator's involvement, I can't tell beyond my own experience. But I do think some of the elements that need to be thought about in the acceptance by the common law world is how it's framed. And I know we'll get to that later, but I know, Niuscha, you've looked at a survey done by Edna Sussman, and I think it was in a report that she wrote with Klaus-Peter Berger. And I'll throw the question back to you in a moment. But just in terms of the other side of the coin, I had a quick look at Queen Mary, and I see Matt Seacombe's on the call, so he might have more insights about if they discuss anything like that. And the only point that I found looking quickly was in response to a question about how arbitrations could be made more efficient, and 12% were in favour of mandatory, and I think the nuance here is mandatory, settlement discussions in the procedural timetable. So looking at that relatively low figure, I think the question itself probably could have been enhanced to the extent that if it's not mandatory, if it's facilitated, if it's voluntary, would there have been a higher response? Because looking at your results, or the results that you analysed in great depth, so I'll turn them back to you, I do think there's a bit of a gap there. And of course, that's not common law driven, but some of this sort of highlighted for me a point that will aid in acceptance. You don't make it mandatory, you make it a party-driven process, which, as you said before, particular windows in the timetable, and it's then a judgment call, I think, in a lot of cases. I mean, I've got cases at the moment where I think perhaps they are willing to settle, and I've got cases where I'm like, there's no way I'm even going to raise this, because they are at loggerheads and fighting and sending 20 emails a day, and it's just not the right time. So these are common law cases. I should emphasize they're Hong Kong seated, at least, involving a mixture of common and civil law parties. But there's a lot of layers, I think, in acceptance. I think overall the concept's warming up, but I think there's still a lot of care has to be taken in the common law world in particular, because they're so skeptical of it, to ensure that it doesn't sort of go off on a tangent. And you really only need one person reporting on an arbitrator that said something that perhaps went too far, and then there's an allegation of bias, or there's a challenge, and all those kinds of things where, you know, it might throw the whole thing back by a few years. But I would turn the question back to you, because you did look at the Sussman survey, and I do think that is instructive, at least from a US common law perspective as to where it's going there.
Yeah, sure. Thank you. Back in 2021, the International Mediation Institute, CCA, Strauss Institute Mixed Mode Task Force published an article by Klaus-Peter Berger and Edna Sussman on arbitrator techniques and their direct or potential effect on settlement. And they, this survey had different parts, but they also interviewed international practitioners. And in response to the question, do you think an arbitrator has a role in fostering settlement? A staggering 78.38% responded yes. So, and these were not only civil law lawyers responding. Further, the tribunal has an important role in helping the parties understand the procedural options to settlement outside of the arbitral proceedings, as well as within the arbitral proceedings, or the arbitrator can have an active role provided this is in line with expectations and wishes of the parties. And expectations is a very important term here in this respect, indeed. There was even another one which said in the responses, it is the arbitrator's duty to encourage the parties to settle the dispute. Now, to have a duty, I think we can somewhere leave it there, but if you look into the rules of institutions worldwide, you will not find a duty as such, but you will always find may facilitate, may encourage, may. So there's always this may, which is very soft. With the exception of, I would say, two rules. One is that the NAI rules, the Dutch rules, newly in force of December last year. They have midstream conferences, and the midstream conferences shall take place. So they must take place with the aim also to have a settlement facilitation, a settlement option there. And then the very clear wording is definitely in the DIS rules. That's the German Arbitration Institute, where there is the arbitrator shall encourage. So instead of may encourage everywhere else in the institutional rules, it's shall encourage. That is really showing a little bit where it is coming from. But I thought the fact that an American is part of the of this task force that has looked at settlement facilitation through arbitrators is very, very important. And it's not just anyone, it's Edna Sussman, and the responses were speaking for themselves, as I mentioned. Yeah.
So pivoting slightly now, I guess this comes to the role of the arbitrator and all of this, which is what we're touching on with the various rules and the way they're formulated, which of course is critical. Why should arbitrators be involved? Shouldn't we just leave it to the parties to work it out if they feel it's appropriate?
There is a very good saying, these are big girls and boys that are dealing with the case, of course. So why would you get involved at all? And again, working on the basis of a survey that was done by the ICC with the report that came out on settlement facilitation 2023. So it was a call by the users. And the call by the users being the in-house counsel who said, we want that, we want this, as I said at the beginning, so that there is a face saving for us to take the first step. You mentioned it yourself, Mariel, the efficiency, time, and especially cost as well. So that all is actually coming not from, the arbitrators who would cut down their own costs because the case would settle, or the counsel who would cutting down their costs. And we should talk about incentives for that in a moment as well. But it is coming from the users. And so if they're the driving force behind it, then we should listen. And maybe it's for us arbitrators to actually adjust. And we can learn so much also from the courts too. So how they are dealing with with settlement. And I think that there it's not necessarily a dichotomy between civil law and common law countries. So I know that we have esteemed judges with us here, but that is something I think, to put it very bluntly, a no-brainer. But I fully agree. You have to have the right environment. Meaning you have to have the council and the parties willing to settle within the proceedings, and you have to have co-arbitrators who are willing to take that step as well. In fact, I have had hesitations when I was a chair with certain co-arbitrators who said, no, 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 let them do what they need to do themselves. We shouldn't get involved. It wasn't clear to me really always why and what the motivation behind this hesitation was. I cannot pin it down, and I don't want to generalize at all on one element. But I do think that the users want arbitrators and the institutions and the rules to actually help them to make use of the entirety of dispute resolution mechanisms, with the outcome not being only the award, but also the settlement. And there's nothing lost in putting that in the procedural rules on the PO1 or in the institutional rules, but for the monetary aspect of it. But I even think there, Mariel, we might have a solution. So we will talk about it as well. But for the time being, what do you think, Mariel, in your experience, when would be a good moment in the proceedings to raise the possibility to facilitate its settlement? When is it too early? When is it too late?
Thank you. I think just thinking about the cases I've been involved in, and as I said, it's coming up increasingly. I think it needs to be somewhere in the written documents from the very outset, but it's the sort of dis rule, and I had a disarbitration where obviously the rules say the template CMC points, I think they were, also had a provision in there for settlement. And I think if you put it in, it's coming from the tribunal, which, as you said, is very important. And I think particularly in Asia, or at least where I am in Hong Kong, that's all face-saving culture, where if the tribunal's putting it forward, it's going to have an entirely different taste to it than if it's the parties, or if it's, God forbid, your own lawyers who are suggesting you might want to settle the dispute for whatever reason. So I think the tribunal-driven nature of it is very important. In terms of so I think you familiarise the parties with the idea, put it in your procedural order, but not in any kind of prescriptive terms. I know in our case, or a recent case I had, I think the wording was along the lines of the parties agree, or the tribunal has discussed with the parties that they will look at appropriate windows to discuss settlement later in the case. And of course, you can put it a lot more definitive than that, but we were not sure if we wanted settlement. Also, as a result of our client's instructions, the other party seemed to be on a similar page with respect to how mandatory we wanted that formulated. So that was how we left it. I think in terms of when you actually do it, the midstream conference is probably a good time, but again, you need to be specific about what you're talking about. When is the midstream conference? I've got two cases at the moment. One midstream conference is after document production. So you've got the first round of submissions, document production, then the midstream conference. The other case has the first round of submissions, then the midstream conference, and then document production. So it's all a question of what you're defining as what. But I think generally, to make an overgeneralization, once you've got as much evidence on the table as you think is appropriate for the parties and the arbitral tribunal to have a good view of the case, that's probably a good time to discuss it. I think in terms of what you discuss, it's obviously case dependent, but also one point that I think needs to be brought out here, the arbitrators really need to be on the ball.
Mm-hmm.
Because if you're giving any kind of opinions or directed questions to parties that might be aimed at procuring settlement, And particularly if you're a tribunal of three, you have to be very, very confident that everyone is 100% up to speed on the case. Because what you don't want happening is the classic where someone's too busy, they think they can just wait until the week before the hearing and sit down and block 3 days to prepare for the case. Because if you've got someone like that who's kind of playing along and something, a question is poorly worded, let's put it that way, I think you really do have some due process issues there, because you're trying to facilitate a settlement, or you're offering to facilitate a settlement without full knowledge of what's on the table from an evidentiary perspective. So it's yeah, the timing is very critical, but also the level of preparedness of the arbitrators.
Well, I see that as actually the bonus point of the whole discussion, to exactly have arbitrators already be prepared pending the whole proceeding, not only prior to the hearing. That's exactly one of the very big benefits of that. And I agree with you that the timing is not very clear. I always thought that it is very helpful to have a midstream conference where you can discuss various things or put these clarificatory questions to the parties prior to the document production phase, so that the document production phase can be further limited and more focused on the really important questions that the tribunal might have gathered, and having read, as you said, and be prepared, the first round of submissions.
Great. So, Niuscha, I know you've got a few very innovative views about how we can implement this in practice and what kind of safeguards we need to have. So what would you think is, in terms of safeguards, protections, due process issues, what's advisable or necessary if the tribunal is going to go ahead with this kind of role?
Yes, I had a go on a couple of provisions, once drafted, I think 2 years ago, and then I went a little bit on a roadshow with that to India and in a blog post, and Finland and elsewhere. So I'm very happy to bring it to Australia as well. But basically what I had in mind were like 4 provisions where we can maybe use the wording of that and certain that and the procedural rules. And 1 or 2 of them actually refer also to the safeguarding, but also the no prejudgment and no adverse inference to be drawn. And that is from the party's perspective, so that if when a party approaches the other one with a settlement proposal, whether during the settlement window or even otherwise, then neither party nor the tribunal may draw any inferences on the strength or weaknesses of any argument or claim that any of the parties may have raised in the arbitration. That's very, very important, and that is with respect to the content of the proposal or from the making of the proposal itself. And then there is another safeguard, and that's for the tribunal and the integrity of the award, is that there should be no first of all, no bias on the tribunal side, and also that the parties will not take these settlement facilitation efforts as a reason for challenging the arbitrators or challenging the award. What I had done in cases where the parties had asked for preliminary views of strength or weaknesses, actually to set up an undertaking, have it signed by the parties, each side, and then with that undertaking going forward, and not doing anything before that undertaking was in safe hands of the tribunal, again signed by the parties. I think it's very important also to show the seriousness of the matter and the impact that this discussion can have on the entirety of the proceedings and of the award.
I know we're at time.
Yes.
And I'm speaking under Emily and Jacqueline's control, but I know you also have, and I know this was supposed to be a question to me, but I think you've got more to say on this. Your very innovative incentive for arbitrators, if I can call it that, you will correct me. You've also drafted something along those lines about how tribunals could still get fairly remunerated. And I know we're not going into remuneration here, but perhaps you could shed some light on that as well, just briefly at the end.
Thank you, Mariel. Indeed, I will put that question back to you from a counsel's perspective as well, because it's we need an incentive. Everyone needs an incentive. We know we discussed, okay, the users, they might want to settle, that's fine, but what's happening with the arbitrators and the council that are involved? And so I think that the institutions should actually take a very close look at the efforts of the tribunal, how prepared it is, how much time it has spent, be it by putting the clarificatory questions to the parties, be it by convening the midstream conference, and with that always then leading to a potential settlement. And then once that settlement has actually occurred, for the tribunal not to be punished, but rather to be honored, because from the parties' perspective, they have a budget already that they put at the beginning of the case, at the side for this case. And when I spoke to in-house counsel, they said we're very happy to pay the arbitrators, if not the entirety, of course, but at least a lot of it, because they have saved us so much money, and that is now, of course, meaning also so much money for external counsel. So, Mariel, how to deal with the external counsel incentive there?
I mean, we're service providers, aren't we? And, putting my counsel hat back on briefly, I think a process done well, okay, the external counsel will not make their hearing fees, but you won't make your hearing fees either if the parties kind of go off on a tangent. And I'm sure I'm speaking to a lot of people on the call today. We've all been in a situation where your party goes suspiciously quiet for a few weeks, and then you get this poorly drafted, I'll use that term, I was about to use another term, but not appropriate for public use, poorly drafted settlement agreement, and you find out that the reason they've been quiet is because they've been off in a back room with the other side trying to bash something out that resembles a settlement. And in that case, you don't get your hearing fees either. So I think from a council's perspective, that alternative, your alternative, is always going to be favourable. And at the end of the day, we're servicing our users, our clients. You've spoken to in-house counsel, they've given this feedback. And I think it's very critical for the viability of the system of arbitration. And this is, an entirely different conversation for a different day. But I do think as counsel in that process, you have to have an interest in something like this, which enhances the viability of the system.
Thank you.
So we're done, Emily, I think.
Yeah, fabulous. Thank you so much. This is super interesting and very insightful. And I think we already have a hand up, so I will hand it over to Doug Jones, and anyone else, feel free to jump in afterwards with your questions. Doug, please go ahead.
Thanks both. I think this is a hugely interesting topic, given the abysmal failure of the ICC Commission to produce anything useful in their paper on facilitated settlement. Two quick comments. I have found a distinct lack of appetite by parties at the commencement of an arbitration to provide for a mediation window. Suspicion of delay seems to be the main motivation for declining that. Secondly, I have a process of what I call an issues CMC, which is my midstream CMC, where I, or the tribunal, summarises what we think the parties are arguing and asks them to comment on whether the tribunal's got it right or not. And in that context, I have seen some settlements where the parties, perhaps for the first time, properly understood what it was that was between them. And that process would, I think, facilitate the idea of perhaps using the midstream CMC as a juncture at which to encourage people to arbitrate. The DIS work recently on promoting their concepts is, I think, particularly useful, but I think there is an underlying unwillingness for both civil and common law arbitrators to participate in this process, and it's very, very sad.
Thank you very much. Excellent point about the issue CMC, and the DIS indeed has put all its efforts together now to actually have a report which is very lengthy, but actually the report itself is shorter and it has many annexes. But having said that, I think where it goes a little bit maybe to the more uncomfortable environment is when we talk about what the German arbitrators within Germany in domestic arbitrations would do is this preliminary views to have that as a standard, and I think that's when it goes maybe a bit astray. The midstream conference, I see that as one of the main benefits for everyone, and I actually try to put it into the procedural calendar whenever possible, even when it is not clear whether they want to settle or not settle or whatever, but just have that midstream conference already there. I haven't employed yet the issue CMC that you have invented, Doug, but I find it very intriguing, and I can see why the parties only then would actually know what the case is about. But it requires, again, proper work from the tribunal already in the middle of the proceedings as well.
Thank you. Are there other questions, comments, experiences to share? Albert.
Good evening. Just want to make one comment. The CEDR rules on facilitating settlement in international arbitration have been around for about 15 years. They deal with everything that's been commented on this evening, a mediation window, the arbitrators to express a preliminary view, albeit with the consent of the parties, even proposing a method of settling the dispute, meeting the parties, conducting a mediation, but without private conferences. There's no reason why the tribunal couldn't, at the first preliminary conference, cajole the parties if they thought it was appropriate to adopt those rules in the same way as the IBA rules on the taking of evidence are commonly adopted. That is, the tribunal may have regard to, but not be bound by those rules if they see there's some appetite for this sort of process.
I think you started off to say that they're around for about 15 years, and it's true. It's so yeah. There is obviously this hesitation, but they are excellent rules. They have been updated as well. And I remember also at an ICC Commission meeting, must have been also around that time, Gabriele Kaufmann-Köhler made gave a very good speech about settlement facilitation through the arbitrators. It just didn't pick up yet, and I don't know. I don't know what to do about that. But that's why I say we have to look at the courts. We have to learn from the judges. Why is it working there, and why is it not working here? So that is an own analysis in itself, I think, in the psychology of the parties and the different forum. Yeah.
Thank you, Albert. Any other questions, comments from the audience? No, thank you. Well, thank you so much, Mariel and Niuscha. I think we all learned a lot today. It was really informative and very practical as well. So we're very lucky to have you with us, and great to see everybody on the call, and look forward to seeing you at our next episode or at Australian Arbitration Week in between.
Thank you.
Thank you very
for
much.
having me. See you in Sydney.
Thank you very much.
Thanks.
Thank you all. Good to see you.